Hi folks, this is Andrew Weissmann. This is actually my first sort of long form YouTube video. I'm putting it up on my YouTube channel. For those people who don't know me, I am a former federal prosecutor, worked for a long time at the Department of Justice, including I was general counsel of the FBI. But let's move on to why I'm here. But if you don't like YouTube channels, you can find me as well on Substack, and I also do a lot of commenting for MSNBC. I want to talk about Eric Adams. A lot of you know what is going on, which is that the mayor of the city of New York, Eric Adams, is under criminal indictment for 5 felonies, and the new Trump administration, the acting Deputy Attorney General, Emil Bove, ordered the assigned prosecutors to move to dismiss the case without prejudice. And they said the case was brought too close to the primary. That was, in my view, total BS. They also said it's interfering with the mayor's ability to carry out Trump's policies. Kind of a remarkable thing. The prosecutors in the Southern District of New York who were assigned to this resigned. The Deputy Attorney General moved the case then to be assigned to the Public Integrity Section in Washington. Those people also resigned, and ultimately he found one person, according to the reporting, on threat of firing everybody. But ultimately, just the other day, there was a hearing before the judge here in New York, and Emil Bove, the acting Deputy Attorney General himself, showed up. And I wanted to talk about one of the things that he said because it's so concerning. He told the judge that the law is that he has very little discretion here to deny a motion to dismiss the case without prejudice. That's true that there's limited discretion in the law, but he said, Judge, even if you found that there was a quid pro quo between the Justice Department and Eric Adams and his defense team, even if you found that, that would be insufficient to deny our motion. And I want to talk about that because I think that needs sort of unpacking. First, a lot of people have said, gee, isn't it improper for the Justice Department to be telling a judge and prosecutors to dismiss a case when they're not saying there's a factual problem in the case or a legal problem in the case? And that's not quite right. A lot of times a prosecutor will think that the law supports a charge, the facts support a charge, but for a variety of reasons, they think that the person shouldn't be charged. In fact, one of the hardest parts of being a prosecutor is not the issue of can you charge, it's a question of should you charge. Let me give you a really obvious example. If you're dealing with a defendant who is elderly and sick, you might factor that in terms of deciding they really don't need to be criminally charged, obviously depending on a whole range of other factors. But that's just a way of saying that there are external things that can come up that are unrelated to the facts of the crime and the law governing that crime. So it's not so much an issue that Emil Bove made this direction to the prosecutors to dismiss the case, or that he went into court and told the judge, we're not asking for the case to be dismissed because our request is unrelated to the facts of the case or the law. That's, to me, not so unusual, although typically if you were going to move to dismiss a case, which rarely ever happens. I mean, this is such an unusual circumstance. Usually it is because something has happened with respect to the facts or the law has changed that leads you to think you no longer have a viable case. The issue to me is that statement about quid pro quo, that Judge, even if you found that we had a quid pro quo with Eric Adams, that would not be enough. And here it's worth remembering, as other people have noted, that the government wants the case to be dismissed without prejudice, meaning that it could be brought in the future. So this is like the sort of Damocles hanging over Eric Adams' head if he does not carry out the Trump administration's bidding. That's the argument that led the prosecutors to resign, saying that that's an improper use of the criminal law. And I think they're right, that there's certain quid pro quos that have to be considered illegal and or improper use of the Department of Justice's criminal authorities. And I think, again, I'm going to unpack that even a little bit more. There are quid pro quos in the criminal justice system that people have found to be lawful and happen all the time. Here's a classic example. A defendant cooperates with the government and they enter into a cooperation agreement. That is the government saying, if you do X and you testify truthfully and you give us all of this information, we will do certain things. We will write a letter to the judge explaining not just the crime you committed, but also all of the cooperation. And the judge typically will give that person, if they've lived up to their bargain of testifying truthfully and providing that information, will give them a lesser sentence because of that cooperation. And so that is a deal that's struck where the government wants cooperation, the defendant wants the opportunity to get a lower sentence. So there is that exchange. In the corporate area, I used to do a lot of criminal cases involving corporations when I was chief of the fraud section at Maine Justice. You could decide that a company can have a deferred prosecution agreement, almost like a kind of probation, but the condition is that they have to do certain things. They may have to pay a fine. They may have to have a better compliance program so that they don't recidivate, or you reduce the risk of recidivism. So there is that ability to have quid pro quos. Here, though, the alleged sort of quid pro quo has nothing to do with a criminal law enforcement goal with respect to reducing the level of crime. Let me give you an example. What if, and it's a hypothetical, here's a quid pro quo. You've indicted a Democratic congressman, and you say to the congressman, I will dismiss the charges without prejudice so long as you vote for everything the Republicans want. So that's a quid pro quo. That's using the criminal justice system to essentially, in my words, extort a result. It cannot be that that's the case. In the same way, it could not be the case that Eric Adams just could say, you know what? I'd like you to dismiss the case without prejudice, and I'm going to give you a bag of cash to do that. Or the Deputy Attorney General says, I'm willing to do it if you give me a bag of cash. Now, by the way, I'm not saying that's what happened here, but the point is that there have to be certain quid pro quos that the law cannot accept. And so when Emile Beauvais said to the judge, no, even if you found that there was a quid pro quo here, that you still have to go along with it, that is something that cannot, in my view, be the law and is an incredibly dangerous statement to come out of the mouth of somebody in that position in the Justice Department. It really, to my mind, is sort of the beginning of the end of the rule of law and makes us much more similar to countries like Russia and Hungary, and in many ways maybe even worse. And that's an area where I have my eye very much on what Judge Ho does here and whether he sort of unpacks the statements that have been made to him. And I think that what I would do is I would hold a factual hearing, and I would not just hear from the parties without being under oath. I would say, you have to take the witness stand. I want to make findings about what exactly what happened here. Was there a quid pro quo? And if so, what was the nature of the quid pro quo? Because there have to be certain types of deals that are struck that cannot be something that the court blesses and goes along with. So that's my unpacking of a really, really topical issue. We don't have the final chapter. Stay tuned to see what the judge does here. And as I said, it could have really big consequences for not just the Justice Department, but for the rule of law in this country. Stay tuned for more on this topic, this very topic, on my YouTube channel. And I've also been writing about this issue for Just Security, which is a legal forum connected to NYU, where I'm a law professor. You can also subscribe to my Substack. There's free content, actually a lot of free content. You can, if you feel like it, you can also be a paid subscriber. And I post there and discuss issues of the day like this one. But it's nice to have this forum to discuss it more in depth. And then finally, I have a really terrific podcast co-host, Mary McCord, and our podcast is called Main Justice. Some of you may remember it because for a long time, up until this January, it was called Prosecuting Donald Trump, and it is renamed and rebranded, and it is now called Main Justice. It is sponsored by MSNBC, where both Mary and I are legal analysts. So anyway, thanks for staying tuned. I hope you enjoyed it. I hope it was edifying. I will look forward to getting your input and notes and questions so I can respond to those. Thanks again.